Hi, thanks so much for joining our webinar today. My name is Jessie Peterson. I'm the Director of Education here at SunRay Construction Solutions. SunRay secures $10 billion annually for GCs, subs, and suppliers. We are a national construction document service. Today's webinar is conducted by the incredible Lynn Thompson, a Mississippi construction lien law expert. Today's webinar topic is, what happens after I file my lien? How do I get paid? So without further ado, I'd like to introduce the fabulous Lynn Thompson.
Well, good morning to all of you. It's a beautiful day where I'm sitting in Ridgeland, Mississippi, and this seems very appropriate for our talk today. I've got a load of construction workers changing out the windows in my building, so you may hear some construction traffic and noise, which I think is kind of funny and appropriate for the day. I've been practicing law for well over 30 years. I went to law school at Emory University and came to Mississippi in the late 1990s. And it wasn't until 2014 that Mississippi had a lien law. So it's relatively new compared to the span of my practice. So let's get into what happens after you file a lien. All right. The last webinar, we got through the process of filing the lien, all the appropriate steps and time requirements for filing a timely lien. So we're picking up from there. And today's webinar starts with the understanding that you have a properly filed lien, that you filed it in the correct location, the correct county, and that you gave the proper notice of the filing of the lien within 2 days. Okay, after that, the big thing to remember is to enforce your lien to get paid, you're going to have to file either a lien action or a payment action. Of course, if the mere filing of your lien resulted in your getting paid, we'll address that later. But let's assume for now that you filed the lien, the party against whom you have a claim, whether it's the owner or a prime contractor or a subcontractor, or if you're a materialman to a subcontractor, let's assume that hasn't shaken any money loose. So you have 2 ways to go. One is a lien action, and that's a civil action against the owner of the improved property. Another type of action is the payment action, which is a lawsuit or a proof of claim in a bankruptcy case if the person against you have a claim filed bankruptcy, or a binding arbitration to establish the amount owed to the lien claimant. All right. Sometimes the payment action and that's typically made against the party the party that hasn't paid you. You know, the party with whom you've got a contract or a purchase order and they haven't paid. So typically that's where you file a payment action directly against the party that you have the payment dispute with. But sometimes if there are instances such as if the owner has not made the payment to the prime contractor, or there's a bankruptcy or a death of an individual, or a payment due under the applicable contract agreement cannot be had, then the lien claimant, that's when you can force the lien directly against the property. And if you file within the required time. And the lien claimant is limited to judgment in rem, meaning you can only satisfy the amount of your lien against the property and no personal liability upon the owner of the property. So a lien claim has some limitations on it. Very, very important to remember this. A lis pendens notice shall be filed with the commencement of this action, with the copy going to the owner and the contractor. A lis pendens notice, typically it's the clerk of the county wherein the lien or payment action has been filed. It's a book that's kept of all litigation that's filed. And say if you're doing a property search, if there are any actions pending against a piece of property, it would appear in the lis pendens book. In Mississippi, if you do not file both a timely payment or lien action or if if you don't also file at the same time the lis pendens notice, then you will not have a lien right. You've got to do both of those, and there's some case law in Mississippi where the payment of a lien action was timely filed, but the lis pendens notice was not filed at the same time, and there was no lien right. And the purpose of filing the lis pendens notice is to give notice to other claimants that there is an action pending that affects the ownership or liens against that property. Okay, now where can you file your payment action? Several places. County court. In Mississippi, county courts have a jurisdiction of up to $200,000. You can go to circuit court. Chancery court is typically where the lien action would be filed. And there's arbitration. And just make a little footnote about arbitration. That requires a little discussion later. Now, when must you file your payment action? Generally, it's 180 days after the date that you filed your claim of lien. So within 180 days of recording your lien, you must file the payment action. And that period can be shortened to 60 days if a notice of contest of the lien is filed. So what you do is you mark your calendars from 60 days after and 180 days after filing the notice of claim of lien. Now, the 60-day notice, 60-day period, that's to benefit the owner or contractor against whom the lien may be filed, so that if they want to bring an action forward sooner to resolve the amount claimed or to resolve the lien, they can shorten the 180 days to just 60 days. So an owner or an owner's agent or attorney, or the contractor's agent or attorney, may elect to shorten the time prescribed, the 180 days, in which to commence a payment action to enforce any claim of lien. And they do this by recording a notice of contest of lien in the Chancery Clerk's office. And then they must also send proof of delivery to the claimant. In other words, they have to give notice to the lien claimant that they have filed a notice of contest of lien. And this notice to the claimant must be sent via registered or certified mail or statutory overnight delivery at the address noted on the face of the lien within 7 days of filing the notice of contest of lien. So make sure when you file your lien that you've got your correct address, or the address where the notice of contest will be sent, because you need to keep your eyes peeled for that. If that arrives, then you've got 60 days instead of 180 days to file your payment action. And if the time gets shortened to 60 days and you file your payment action on the 90th day, you do not have a proper lien anymore. Now, this is what, if you look at the Mississippi statute, this is what a notice of contest of lien could look like. I don't see any reason not to use these statutorily authorized forms, but so long as you use this or something very similar to it to give notice of contest of lien, it should be sufficient, and also provided that the notice of contest of lien is properly filed. So that's what that looks like. Okay, now, how do you commence a payment action? Well, it's the same as any other lawsuit in Mississippi. You have to have a summons and a complaint. And you see there the demand for arbitration in parentheses. Again, I'll get to that in just a second. But so the defendant shall be summoned, as in other actions at law, to appear and defend the action. If there are non-residents, you have to serve them the same way that you would a non-resident in any other case. And default judgments can be entered if they fail to appear, but is treated like any other lawsuit in terms of how it's filed and served. Okay, if you do not commence the payment action, it renders the claim of lien unenforceable. And again, The 180 days becomes 60 days if you get the notice of contest of lien. All right. Extinguishment of lien if payment action is not timely filed. If it's not timely filed, it is extinguished upon the earlier of 90 days after the filing of the notice of contest of lien, or 180 days from the date of the lien filing if no payment action is filed in that period. And there's no release or voiding of the liens that's required. In other words, it just evaporates. It's as though the lien was never filed. No further action needs to be taken by the person against you have the claim to remove the effect of the lien. Okay, who do you have to have as a party to enforcement of the lien? It's not necessary that you sue the party against who you have a direct contractual relationship. They're not a necessary party, but they may be made a party if the action is to establish the amount that's owed. Typically, you would include as a necessary party the entity against whom you have a claim. In other words, if you're a subcontractor and the contractor is the person whose debt due to you resulted in the lien, typically you would make the prime contractor a party to that action. Design professionals, contractors, subcontractors, any or all of them may intervene in the proceedings at any time before a judgment for the purpose of resisting the establishment of the lien or of asserting against the lien claimant any claim of the contractor or subcontractor. In other words, if the debt is contested, these other parties can intervene in the proceedings and assert their right to defend the amount claimed in the lien. They can defend it as they would any other action. Okay, if there's an action against the owner to enforce the lien, any party to an action against the owner to enforce lien against the property may put in issue the fact of indebtedness or the existence of the lien, and may interpose any other defense or join any counterclaim applicable to the action. If it's ascertained that the plaintiff has a lien as claimed, judgment will be entered for the amount secured plus interest and cost against the party that was liable for the debt. Now, this is a very important statute to know. This is 85-7-4053C. This is one of the very few statutes in Mississippi that gives the court the authority to award cost, interest, and attorney fees. The general rule in Mississippi is for breach of contract actions, there is no right to attorney's fees. Even in negligence, you'd have to establish a gross negligence standard or bad faith intent to injure standard. So be aware of this. And it's a good tool to use if you're trying to resolve a payment dispute or just get your payment. If you're in the habit of using demand letters, you want to know this statute and include it in there and let the party know who's not paying you that if forced to file a lien and then enforce it, that the lien claimant may be awarded reasonable costs, interest, and attorney's fees. So that can be a weapon. All right. Now, whenever any lien has been fully satisfied, the holder thereof shall file a cancellation of it in the record in the office of the Chancery Clerk. If for some reason you file a lien and it results in payment from the debtor to you, then you must make sure that you file notice of cancellation of the deed, or that may result in an improper cloud of title. So you're not finished. Once you get your check, you've got to go this additional step and do a proper filing of the cancellation of the lien. Okay, here's the penalty. If you fail to cancel a lien, any holder of a lien who, after being fully paid, fails for 15 days after demand in writing to file the cancellation is liable for the amount of $500 per day that the required cancellation is not timely filed, and again, plus reasonable attorney's fees and costs. So you get paid, you've got 15 days maximum to go file the cancellation of lien, or you will be fined $500 a day. Okay, I mentioned a couple of times before about that there is no waiver of the right to arbitrate. So nothing in Mississippi's lien law prejudices the party's contractual rights to arbitration. So if the contract or subcontractor purchase order has an arbitration provision, the contractor, subcontractor, or materialman can proceed with the arbitration in lieu of a payment action in court. But just know this, that the only thing in Mississippi that constitutes an action that stops the period of time in which you've got to file is a payment action. Typically, what I would do is file the payment action and include in there that it's being filed for the purposes of ensuring compliance with the Mississippi law to file a payment action within 180 days or 60 days, but that the right to arbitrate is preserved. If you want to waive the right to arbitrate, you don't have to include that language, but that's something that I would want to preserve. So I think you should do two steps. File the proper action in a court and reserve the right to arbitrate, and then subsequently file a notice, a demand for arbitration. So filing a lien doesn't give up your right to arbitrate. Okay, now all liens shall have an equal priority and be first paid out of the proceeds of the sale of the property, meaning whoever gets to the filing of the lien first doesn't get all the money. Now, if there are other lien claimants who fail to timely and properly file their lien, their payment or lien actions, they will be shut out. But the liens have equal priority, and no one is going to get all of the money provided that they timely file their lien action. And this is another reason that you would look in the list pendants notice to know what other actions have been filed against that property in case you want to join in on those suits. Okay, these are just a few very general housekeeping particulars, but in order to file an action in Mississippi, if you are an entity, you must be registered with the Mississippi Secretary of State's office. So if as an entity, if you've let your good standing in Mississippi lapse, you need to ensure that that is kept active, or that you get it reactivated so that you can be a proper plaintiff in Mississippi. Also, maintain your current certificate of responsibility. Typically, if you've performed work during the pendency of a valid certificate of responsibility, it won't be a problem. But unless you've just ceased to do business as a contractor in Mississippi, there is no reason that you should let your certificate of responsibility lapse, and sue in the name of the correct business entity. If the entity was XYZ Corporation that filed the lien, then that is the name in which the lien or payment action must be filed. All right, we have reached the end of this. Any questions?
Yep. So first of all, Lynn, you are incredible. Thank you so much for putting on this webinar for us. We really do appreciate it. We do have a couple of questions that have come through. The first one, it says, if the lien is contested, what do I have to do within that 60 days? File a lawsuit? And then the follow-up question for it is, the notice of contest on the lien must be delivered back to the contractor that's filing the lien. What if it gets lost in the mail? Does that affect the notice of contest and still make it valid, or would it keep it at the 180 days?
Okay, in response to the first portion of the question, if a notice of contest of lien is filed, yes, you must file within 60 days. That is a requirement. The notice, you cannot wait to 180 days, and it's not 60 days after you receive the notice of contest. I would interpret that to be within 60 days of when you filed your lien. Okay, so don't look at that as 67.
Good distinction.
It's still 60 days. I was trying to find, okay, it has to be sent by registered or certified mail or the statutory overnight delivery at the address noted on the face of the lien. Okay, so registered mail, certified mail, there's going to be a record of at least when they got the registration number or the certified number, and the post office where it's delivered, in particular for certified mail, will keep a track of all the number of times that they have attempted delivery or to give notice. Statutory overnight delivery, that's going to be a FedEx or UPS, all of those which have tracking numbers. So my point is, I think it's going to be, I think it's very unlikely that it would get lost in the mail or that it couldn't be tracked through the mail or overnight delivery services. But if, I think the burden would be, this would be my position, that the burden would be on the sender to show that they complied with registered or certified mail or the statutory overnight delivery. If for some reason it were literally to be lost, under common law in Mississippi, there's the mailbox rule, and that is that something is presumed to be delivered within 3 days of when you put it in the mail. I don't know that that would prevail here, where the requirement is for registered or certified mail. I'm not aware of a case that addresses this directly. My hunch would be it would be an issue of fact in order for a lawsuit filed after the 60 days to be maintained.
Okay. All right. Wonderful. Well, thank you for making those distinctions for us. I appreciate it. Another question that came through, and it says, should you file the cancellation of a lien even if they pay via check or credit cards within 15 days? What about chargebacks and bad checks? Wouldn't your lien rights then be voided?
Well, I would require that they pay in a certified check. And it's 15 days, or wire the money. So if you're worried about filing the lien, the cancellation of the lien before the check is cleared, the 15 days should be enough time for even a regular check to clear. But I would insist on a certified or cashier's check or wiring funds.
Or cash. Cash always works. All right. Well, thank you for making that clarification for us as well. Are you able to forward along to the next few slides? I know you had gone back to show us within your presentation. That's all the questions that have come through so far. If anyone does have another question that wasn't addressed, please feel free to reach out and we'll be sure to answer any questions as soon as possible for you. We're getting to the last little bit here. There we go. And then if you can go to one more slide for me. Wonderful. All right. So here are some of SunRay's resources to help you guys stay organized, know your deadlines, and secure your lien rights. Go ahead and scan that QR code to access these incredible resources. You've got deadline calculators. There's a project information sheet that's wonderful. Please utilize it. It's just going to help you ask all the questions at the beginning of your project to find out, who your customer is ultimately working for, and find out, all those entities that are upstream from you. It will help the process go a little smoother for you. So please utilize that. Remember, each state has its own unique deadlines and documents that are required. So please make sure that you are following that particular state's rules and laws. And if you're working in a nearby state that you're not aware of what their laws are, check it out on there, because it will definitely give you that heads up of knowing what you need to do. And then next slide, if you don't mind, please. All right. If you don't mind, take a moment to give us a review on Google. We'd really appreciate it. It takes about a minute of your time, but it helps us with the feedback, understanding what it is that you're looking for, better webinars that we can deliver to you. And it just helps to get the word out to other contractors and suppliers like yourselves. So we really do appreciate it. So give us that review if you can. And then the next slide, please. All right, and with that, that is all we have for you guys today. We hope that you all had a wonderful, experience and got a little nugget of information out of this webinar. We hope to see you guys at our next webinar. Again, thank you, Lynn. You really are incredible, and I hope you all have a wonderful and beautiful sunny day. Thanks, everyone.